Namaskar. As instructed on behalf of Panun Kashmir, I hereby reject the proposed draft Kashmiri Pandits Recourse, Restitution, Rehabilitation and Resettlement Bill 2022, which not only subverts the proposed Panun Kashmir Genocide and Atrocities Prevention Bill 2020, but also undermines the pain, agony, trauma, struggle, and resilience of Hindus of Kashmir living in exile, which amounts to denial of genocide. The monumental impact of the film Kashmir Files on on the national narrative on Jammu and Kashmir and the exposure of genocidal war unleashed on Hindus of Kashmir is sinking into the consciousness of the nation. For the first time, it appears that stranglehold of falsehood and deception is breaking as this transformation is taking shape and genocide inflicted on Hindus of Kashmir is being recognized as the cardinal feature of separatism in Kashmir. A sinister, self-defeating, and lacerating process has been set into motion by those who call themselves as the co-sponsors of Kashmir Files. While Kashmir File goes a long way in establishing that a genocide was inflicted on Hindus of Kashmir, co-sponsors have earnestly unfolded its project of denial of Hindu genocide by associating with a bill introduced by Congress MP Vivek Tankha. What is this bill? What are its contents? And how is it a project of denial of genocide in Kashmir? By its content and implication needs to be stated. It is need of the hour because not only does this bill scuttle and undermine the purpose of Kashmir Files, but also brings to light that the denial of genocide can be done best through naive minds suffering from gross incomprehension belonging to the victim community itself. It is necessary to interpret the statute to find out the real intention of the statute, to determine the intention of the legislature conveyed expressly or impliedly in the language used. In the process of interpretation, several aids are used. They may be statutory or non statutory. Statutory aids may be illustrated by the General Clauses Act 1897 and by specific definitions contained in individual acts. Non statutory aids are illustrated by common law rules of interpretation and also by case laws relating to the interpretation of statutes. Interpretation of statutes is required for two basic reasons. Legislative language may be complicated for a layman and hence may require interpretation. And legislative intent. The intention of the legislature or legislative intent assimilates two aspects. One, the concept of meaning, that is what the word means, and two, the concept of purpose and object, or the reason or spirit pervading through the statute. The fundamental principle of statutory interpretation is that the words of a statute can be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act. The object of the act and the intention of the legislature, therefore, important point to be taken care of in the context of interpreting statutes is intention of the legislature. Statute must be read as a whole in its context. Statutes should be construed so as to make it effective and workable. Using the acceptable tools of interpretation of statutes, now let us examine the bill titled Kashmiri Pandits Recourse, Restitution, Rehabilitation and Resettlement Bill 2022, presented by Shri Vivek K. Tankha, Member Parliament. It is for the rehabilitation of the Kashmiri Hindus. In our opinion, this bill deserves to be rejected outrightly. Since any executive or legislative action has to be construed harmoniously with other applicable laws, moreover, it cannot be contrary to any provision of the Constitution, particularly any provision of Part 3 of the Constitution. This bill is in violation of Article 14 and the propositions laid down by Honorable Supreme Court in Dalmia case. Article 14 forbids discrimination by law, that is, treating persons similarly circumstanced differently and treating those not similarly circumstanced in the same way, or has been prettily put, treating equals and unequals as equals. Article 14 prohibits hostile classification by law and is directed against discriminatory class legislation. It prohibits class legislation but allows reasonable classification. It is well settled that in order to meet the test of Article 14, classification must be based on intelligible differentia, which distinguishes persons or things that are grouped together from those that are left out of group. And the differentia must have a rational nexus to the object sought to be achieved by the executive or legislative action. Though we would like and would any time prefer the nomenclature used in this bill, but the law qualifies a term through its own prism. Though two bills, Tankha's bill and PK bill, cannot be compared, while the latter, PK bill, defines genocide, cultural genocide, economic genocide, it also envisages in itself the redressal mechanisms in accordance to provisos of international law, conventions, and treaties, and is harmoniously constituted with other laws applicable in India. It is derived from comparative jurisprudence and comparative legislation. Whereas former, the Tankha bill is abject compromise and completely is in denial of genocide. Denial can range from outright rejection of facts, that's known as literal denial, to contestation of the meaning of the events or target of blame, that is interpretive or implicatory denial, to acceptance of only a portion of the truth, that is partial acknowledgement. Literal denial is by the genocidaries or the perpetrators. Interpretive or implicatory denial is by the state, and partial acknowledgement by collaborators and state. And the nomenclatures used in Panun Kashmir Bill are derived from laws, case laws, and precedents, and are defined in Part 1 of the bill with references to the laws where from they have been derived. We do not have any reason to doubt legal acumen of the proposer of bill, but such act implies callousness on his part and questions both seriousness of the effort as well as the intent. We are therefore left with no option but to term the bill as colorable and attempt to play to a gallery, or purely a subversive attempt to scuttle Panun Kashmir's Prevention of Genocide and Atrocities Bill. Since we are victims and survivors of genocide, we do not have the luxury of being complacent or naive. Survival is a privilege which entails obligations. We have to ask ourselves what we can do for those who have not survived. The answer is we want to be their mouthpiece. We want to keep their memory alive to make sure the dead live on in that memory. We do not think there is any other solution than constantly coming to terms with the past and learning from it. There is no point in minimizing guilt of the perpetrators, bystanders, or collaborators. In order to make it easier for these children to bear the failure of their fathers and grandfathers, their mothers and grandmothers, paramount responsibility of victim is to speak truth, unaltered truth, in order to save the civilization. The author presenter of the bill appears to be in chaos as he himself is not clear what he is asking for through the medium of this bill. In the statement of object and reason of the bill, it is stated 32 years ago, what took place in Kashmir on the night of January 19, 1990 lives fresh in the minds of Kashmiri Pandits as a night of barbarism, terror, and mass killings. Kashmiri Pandits suffered the horrors of genocide and exodus at the hands of militants. Militants, the term used is militants. Thousands were brutally killed, women were raped, houses and temples burned, lives disrupted. This inhumane attack on life and honor of a minority population who were inhabitants of the region for thousands of years led to a complete breakdown of law and order and forced them to leave their motherland, their culture, and their homes behind. Now, thereby completely ignoring the Anantnag carnage and presenting the tragedy bereft of being a premeditated act, and as a consequence, trampling upon the stages of genocide, since intent is a prerequisite to classify crime of genocide. Stages cannot be ignored. Furthermore, in Section 5, Clause 1, Subclause 3 of the bill, it states the release of a white paper on the issue of Kashmiri Pandits documenting all events in the Kashmir Valley pertaining to the atrocities and plight of the Kashmiri Pandits starting from the year 1988 till the enactment of this act within 3 months from the date of the enactment of this act. 1988, the Anantnag carnage took place in 1986, and silent actually exodus started then. And the bill is presenting the situation as a law and order situation. So when the entire community is demanding that, since the community has been subjected to a genocidal attrition from last 700 years, and this seventh has to be last, indicative of the fact that at least 6 times we have attempted fundamental applications of restorative justice for resettlement, rehabilitation, and reconciliation, but failed. What motivated the author of the bill to yet again propose a bill based on the principles of restorative justice when the community is still subjected to continual genocide? Only yesterday, a Hindu driver was shot at in Pulwama, and let us not ignore that few days back, pamphlets resurfaced asking Hindus to leave Valley. It is beyond any reasonable doubt that the intent of bill is not to address genocide. Hence, it is an instrument to deny genocide and to facilitate a scope to protect the perpetrators of genocide of the Kashmiri Hindus. The bill is mere eyewash, and yes, it is in solidarity to the perpetrators and deniers of genocide. Section 1, Clause 3, Subclause 2. Section 3, Clause 2 talks about the advisory committee. From the perusal of the bill, it appears the object of the bill is to somehow rehabilitate, empower, and accommodate members of the sponsors of the bill in the advisory committee. And every attempt to please perpetrators, bystanders, and deniers of genocide to the extent that they are willing to share power with them. As on date, National Commission of Minorities classifies Muslims as minorities. Anyways, I would like to share with you, and this is not part of the official statement, by the way. When asked a brother activist Lalit Kohl, who is based in US, about his opinion on this bill, he described the bill as by the advisory committee, of the advisory committee, for the advisory committee. There is no better explanation than this. Now, let us examine the relevant part which substantiates our claim. The advisory committee shall consist of following, and subclause 2 says, two representatives of non-Kashmiri Pandit minorities of the Kashmir Valley. Non-Kashmiri Pandit minorities, right? So obviously, according to National Commission on Minorities, Muslims are the minorities in Jammu and Kashmir. This is directly handing over power to the extent of certifying a person to be a Hindu and enabling them to decide about resettlement and rehabilitation. According to this bill, to those who are either the perpetrators or bystanders, and in any case, definitely deniers of our genocide. Now, Chapter 3 talks about social, political, and economic rehabilitation. We have been contesting all along, and now it has been established that the term migrant is not only derogatory, but establishes denial of genocide. And look at the audacity of the author of the bill. He blatantly uses this term in the bill. Section 5, Clause 2, subclause 1. To ensure political franchise and to further the right of political participation, a mechanism shall be created for enrollment of all migrant Kashmiri Pandits as voters and provide reserved seats in proportion to their numerical strength in local and union territory legislative body. And the supporters claim that they are demanding one place settlement. In our opinion, this bill is an improvised version of Manmohan Singh's economic package. Nothing more than that. Anyway, Chapter 6 is the mechanism for the safety and security of the Kashmiri Hindus and is in complete violation of it is in complete violation of the principles of non-refoulement, which is mandatory for reparation and rehabilitation of victims of genocide, as per the objects of genocide redressal mechanisms. Since the presenter of the bill is himself not clear about the purpose of the bill, which he wants to achieve, admits that environment being hostile and not conducive for our settlement. So we need to be armed for protection. Section 8, Clause 2, Subclause 4. But despite being aware of the situation, wants the community to return. The chapter about the inquiry commission, imagine victims of genocide asking for a commission to validate that they are victims of genocide, that they have been, thrown out of their native land, that they have been killed, and they have been the subjects of a genocide. They are asking a commission to validate this. And for argument's sake, let us assume the commission, in its findings, established the fact that yes, we are victims of genocide. But according to this, what would the perpetrators be charged for? Under which law? Which procedure law will be followed and what punishment shall be awarded? Dear all, we need a comprehensive law which shall encompass all the required facets in itself, from investigation to trial to punishment to quantum of punishment to compensation. That is how genocide laws are enacted and implemented in the legal systems which have actually enacted genocide laws. Let us not forget, India is a signatory to the Convention on Prevention and Punishment, punishment of the crime of genocide. A three-judge bench of the Supreme Court in Ahmad Hussain Wali Muhammad Saeed versus State of Gujarat observed the object of awarding appropriate sentences should be to protect society and to deter the criminal from achieving the avowed object of lawbreaking by imposing appropriate sentences. The court should operate the sentencing system so as to impose such sentences that reflect the conscience of the society, and the sentencing process has to be stern where it should be. Any liberal attitude by imposing meager sentences or taking too sympathetic view merely on account of lapse of time in respect of such offences will be the result wise counterproductive in the long run and against interests of society, which needs to be cared for and strengthened by a string of deterrents inbuilt in the sentencing system, unquote. What distinguishes genocide is not that it has a different kind of victim, namely groups, although it is a convenient shorthand to speak of targeting groups, rather the kind of harm suffered by individual victims in virtue of their group membership is not captured by other crimes. Precisely is the reason why a comprehensive legislation is required to address the reparation of genocide. And in our case, it is imperative to study it in the ambit of psychohistory, since the attrition is a continual process from last 700 years. That the denial of genocide further is being consolidated in the statement of objects and reasons, wherein the bill places onus on genocide victims to restore Kashmiriyat and cultivate an environment of peace, tranquility, and prosperity in the region. To do so without the active participation of Kashmiri Pandits and other religious minorities shall result in furthering the historic injustice. Be their friends. Dear brothers and sisters of the community, seven exoduses in 700 years. genocide unheard in the annals of history, reducing the Aboriginal community from a proportion of 10% to mere 2%, or probably even less. Hope came post independence, and the community thought that this will end, and a sense of respect and dignity will arrive in a democratic, socialistic republic. However, the Indian state has something else in mind. India continues to use the minuscule minority as a hostage to keep a fanatic and fascist majority under check. Indian state used this minority as an epitome of secular character of a theo-fascist and fanatic community. The acts of majority were clear. From the very day interim government of Sheikh were handed over the reins of power, one assault after the other established beyond doubt the creed and color of majority, but Indian state continues to turn a blind eye, assigning the fate of servitude to Hindus of Kashmir. The final assault came in 1990 when the orchestrated ploy to cleanse the valley came to fore. In 1990, the entire Aboriginal community was pushed out of Kashmir and made homeless. Homeless in a country which was supposedly being governed by rule of law. In 1990, last 700 years opened up like a can of worms and a realization dawned, leading the entire community stand up in one voice, saying enough is enough. Satyam to Patyam. A thought dawned that we cannot allow an indifferent Indian state to play with a 5,000-year-old civilization, using it as a hostage to a fascist and fanatic majority. Many thinking brains gathered their wisdom, and this began a churning process. It was not much which took these thinking brains to realize that it is impossible to live in a society which cannot tolerate a mere 2% minuscule minority. These thinking men, thinking out of box, came up with Marg Darshan resolution in December 1991, demanding a separate geopolitical dispensation in the form of a UT. The resolution we all know was unanimously adopted by the Assembly of Hindus of Kashmir. Its sanctity to us is as that of an act of a parliament. Since this resolution has become basic feature of our struggle and resilience, it cannot be therefore amended, altered, abridged, or taken away. The political idiom born from the womb of Margdarshan resolution was a war cry and an act of resilience of victims of genocide. It was not manufactured, but natural demand which gave a sense of freedom, liberty, and pride to a community which was made homeless. Our community thus learned the proverbial art of catching its own fish. When we talk of leaders and achievements, we cannot ignore the role of great leaders, philosophers, guides like Dr. M.K. Tain, Shri C.L. Guddu, Dr. Agni Shekhar, Dr. Ajit Trungu, Dr. K.L. Chaudhary, Professor K.N. Pandita, Justice Sunil Hali, Senior Advocate P.N. Goja, and many others who gave vision to a blurred community groping in dark and bewilderment. Some of us might say it has been 32 years and things have changed. But they must know and realize that nothing has changed as far as the fascist and fanatic majority is concerned. It's more radical today than ever before. Fluttering of few national flags by security forces cannot be the barometer of change. Hurriyat has been neutered, but so-called mainstream has replaced it. Statements of Farooq Abdullah and Mehbooba Mufti advocating and supporting the separatist ideology are known to all. So the argument of change and peace is as flawed and untrue as sun rising from west. Some may even claim that we have not been able to attain it in 32 years, but they must recollect the often used argument of present day government. The ills done in 70 years cannot be cured in mere 7 years. How do you expect the historical injustice and genocide of 700 years to be reversed in mere 32 years? So the key here lies in patience and upholding what the community has endorsed in Margdarshan Resolution 91. We did not compromise when we had to struggle for food, shelter, clothes. Why should we compromise now? Remember, our perpetrators of our genocide haven't budged an inch even after consigning thousands in an unrighteous demand. Should we, as the followers of Bhagavad Gita, give up this struggle of resilience which, which we know will uphold Dharma? No, we will not. We will continue to strive and suffer, but will never compromise on righteous principle of life. We will not betray the gospels of Lord Krishna. Thank you very much. Namaskar.